Start. The Commission agreed with the view of the inquiry officer that the appellant had contravened specific orders issued by the Postmaster General by granting casual connections from time to time as shown in the report of the inquiry officer. Stop. But in the view of the Commission, this was at the most either neglect on the part of the appellant in complying with the orders of his superiors, or open defiance as he was not prepared to accept the instructions issued by his superiors. The President had before him the inquiry officer's report, the report of the case, the explanation submitted by the appellant, and the opinion of the Union Public Service Commission. Stop. On a consideration of all these materials, the President came to the conclusion that the appellant was guilty of gross negligence and disobedience of orders. Stop. It is true that there is no record of the President having come to a conclusion whether in committing irregularities the object of the appellant was to receive illegal gratification for himself or for others within the meaning of the first charge. Stop. It is also true that the President has, in recording his conclusion, used the same phraseography as was used by the Public Service Commission in making its recommendation, but on that ground we are unable to hold that the President has accepted the conclusion of the Union Public Service Commission that the irregularities were not proved to have been committed with a view to secure illegal gratification for himself or for others. Stop. The President is by Article 320 of the Constitution required to consult the Public Service Commission except in certain cases, which are not material. But the President is not bound by the advice of the Commission. Stop. The President found the appellant guilty of disobedience of orders and also of gross negligence. Stop. The charge against the appellant was disobedience of orders, and that is the charge of which the inquiry officer held him guilty. Stop. The Union Public Service Commission also agreed with this view. Stop. It cannot therefore be said that the misdemeanor of which the appellant was charged was different from the misdemeanor for commission of which he had been found guilty. Stop. The misdemeanor charge consisted of commission of irregularities by disobeying orders expressly issued, and that is the misdemeanor of which the appellant has been found guilty. Stop. Lucknow division was recorded by the Union Public Service Commission in the absence.